the four main topics I'd like to talk about is obviously, and all of this is with the backdrop of a legal basis. So we're going to focus only on the legal side of things and touch a little bit on some of the decisions you'll be making as business people as you start up a venture as well. So the first thing is your corporate formation. The first question is obviously when to start a corporation. Should it be a corporation? Should it be a partnership? What type of entity should I be thinking about? Once you get beyond that first initial question, how do I structure the ownership of whatever entity I'm creating? It's an easy question if there's just one founder, obviously, but it starts to get very confusing and can lead to some interesting questions when you have more than one founder with you. The second, or the third topic is how do I bring on the team? And that could be a team of your initial core group of folks, and it can also extend out to how do I build up the company as well. So we'll touch on some initial employment questions, and the like. And then the final topic I'd like to touch on is just IP protection. Some very basic, fundamental concepts that you might want to familiarize yourself with as you're starting your company, and even actually before you start your company as well. And I should back up just a second. My background is corporate securities, so I'm more of a general counsel, corporate startup attorney at Pillsbury. I've been practicing for 13 years. So my specialty, if you will, is kind of venture financing and general corporate law. So some of the issues I'll be talking about today, like IP, for example, I kind of know enough to be dangerous about and to kind of help you through the general concepts, but I'm not going to be able to tell you the nuances of patent law, for example. But hopefully we can get through the kind of the basic fundamental understanding for you. So with that in mind, let's kick it off with formation issues. Wow. Sorry for the technical difficulties. So three main questions on formation issues that I'd like to address. And this is obviously after you've had an idea. You've probably been working by yourself or with a core group of folks on an idea. You may or may not have been approached by angels yet to maybe give you some seed financing. You may have some seed financing of your own, or you may be just planning to bootstrap your company until you get to that next milestone or that next level. So the first question, when to form a company. Second question, what type of entity? And then we'll talk a little bit about location of formation. And what I mean by that is, where do you incorporate? Should we do Delaware? Should we do California? That sort of thing. Okay. So the first question is, when should you become legal? When should you exist as a separate legal entity as opposed to just sitting there in your house or in a classroom or in a coffee shop talking about an idea? And there's no magic formula. No one's going to tell you at this point in time you actually have to form a legal entity. The general rule of thumb that I like to tell our startups is if you find yourself starting to enter into contracts on behalf of whatever you think this entity is going to be, that could be a good time to start actually forming a company. And one of the questions you should be asking yourself as you're debating this in your mind is really around your personal liability. Because forming a legal entity takes you, in most cases, and we'll talk about some other cases where this isn't necessarily true, but in most cases, when you form your legal entity, you're taking personal liability away from yourself and you're putting it into a legal structure. And under the law, that legal structure is viewed as independent from yourself, from a personal liability perspective. So two things there. As I mentioned, when you're starting to enter into contracts, where you could end up having liability associated with those contracts, if you're hiring consultants to build a website, you're hiring any type of consultant, or you're entering into partnership agreements with other internet sites or whatever it might be, you should start thinking about, well, if something goes wrong with this, do I really want to be on the hook personally for this contract? And again, it gets a little bit more complicated if you have more than one founder, because you need to collectively make that decision, because you would all collectively be personally liable for everybody else's actions on behalf of the entity as well until you form a separate structure. The other thing to mention quickly, if you're going to actually start hiring folks to work for you as employees, I would say that is a tipping point where you want to put some structure in place separate and apart from yourself as an individual. Any questions on that before we?
Do you think it's necessary when you're trying to decide what the shares are, split up
Yeah, that's a great question. Great question. And we're going to get into a little bit about how to divide the pie later on. But certainly if you have more than one founder, or if you're going to incent a consultant or somebody to work for you for equity, that's a great time to start incorporating. Because until you actually incorporate, you're not actually dividing anything up. You're not issuing anything. And you also could run afoul a little bit of the securities rules if you're actually issuing shares that haven't been permitted with the state. So if you're actually getting to the point where you're either bringing on someone outside your core group, because the core group oftentimes will go 6-9 months with an understanding of what the pie is going to look like. But certainly if you're going to bring in somebody and issue them an option or promise them some shares, that's a good time to also incorporate. So. Okay, so let's spend a little bit of time talking about the type of entities. And one thing that is very clear after you work with a startup for just instantly is cost consciousness, right? It's very rare the case where someone's just going to hand you a big check and you can go off and build your company. So in looking at the type of entity, one of the things we often talk about is how much does it cost? And then what are the pros and cons in terms of flexibility down the road? And then finally, what if your company is going to be one where you're actually going to look for VC money? What is the typical model that a VC looks at investing? So a VC, for obvious reasons, do not like partnerships because they don't like to have the pass-through tax aspect of that. The typical VC model is a C corporation, and we'll get into details about that. But those are the types of considerations you think about when you're looking at that. So let's just spend a little bit of time talking about each one. This one is probably the least removed from actually setting up a company, setting up a separate structure, a sole proprietorship. This is one that allows you to execute contracts, for example, on behalf of an entity. You're actually a business at this point. You're recognized by the state as a separate entity. But there are some limitations there. One is there can only be one owner. Second is there's very little legal significance. There is some legal significance, but you're still on the hook from a liability perspective, as the third bullet there mentions. But it is something that allows you a little bit of formality to say, I have a business in place now when you start talking to outside folks, and you can turn that proprietorship into a corporation later. So it is kind of an intermediate step that you can take without it costing a lot of money, without diving into a lot of formalities, but it doesn't give you a lot of protection. So keep that in mind. Partnership, the biggest difference in a partnership between a corporation, which we're going to get to in a second, is a partnership has pass-through tax benefits. So if you're thinking about, well, maybe I can get a write-off from a personal perspective on some of the losses I'm going to take early on, a partnership is a great way to do that because you as an individual, as an owner, and you can start dividing up ownership when you have a partnership. As an owner, let's say you own 20% of that business, you're going to have 20% of the tax implications of that business as you go through each tax period. So as your business in the first 12 to 24 months is racking up these losses, you get personal write-offs as well. The bad part about partnerships is that it can result, depending on the structure, in unlimited liability. So you get the benefit of the tax, but you don't get the protection of against liability for your entity. So there's a concept, though, of limited partnerships where you do get additional protection on the liability. The limited partners in that are protected from liability for the entity. But ultimately, you have to flow it back up to a general partnership where there is an individual who is that general partner, ultimately, who is on the hook from a liability perspective. So this is not a very common structure for a startup. One, because of the liability. It may start out this way because of the tax issue, but ultimately, any startup that's successful, we'll get to it in a second, will ultimately go into a C Corp structure. But I did want to make you aware of that in case you weren't sure exactly how fast this was going to move and you were looking for some tax benefits. About 5 or 6 years ago, maybe a little bit longer now, the state started to create a hybrid animal between corporations and partnerships, and it's called a limited liability company. And this is the organization that, for example, my firm is set up as. We are an LLC. It has the benefits of partnership from a tax perspective, but it also provides for limited liability for the owners. The downside of an entity like this, because you might be sitting there thinking, well, why not an LLC? Because no liability, no personal liability, great tax benefits. There's two major downfalls to an LLC, or not downfalls, but kind of negatives to think about. The first one is VCs don't typically like to invest in LLCs. So if you're out there going to be looking for VC money, they're going to shy away a bit from the LLC because, again, they are long-term investors. They're not looking to have tax implications hit them as your company grows and incurs either losses or gains down the road. That just causes all sorts of problems for them from an accounting perspective, reporting back to their LPs. So the typical structure for a startup looking for VC money is not to do an LLC. The second reason why you might not want to do an LLC as you start out is expense. The cost of an LLC is, out of all these structures that we're talking about, the cost of an LLC is probably the most expensive. And the reason is that third bullet up there. You have to draft what's called an operating agreement. Not you, but maybe your lawyer or your accountant has to draft an operating agreement. And an operating agreement, unlike a corporation, an operating agreement is one agreement that governs all the rules for your entity. And yeah, there are fairly standard agreements out there, but each entity and each founding group has a different set of dynamics. And so you really need to spend some time and care in crafting something like an operating agreement. And for that reason, this structure tends to be an expensive one. Final note on this structure, this is actually a fairly common structure if you're going to have overseas operations. A lot of times what you do is you'll set up an LLC or a similar entity offshore. And if you're going to have operations overseas, this offshore entity is a great way to be tax efficient down the road, for example. It is something that ultimately VCs can get comfortable with. It's a lot more common these days. But it is a complicated structure, and it is one that, again, costs money up front to put in place correctly, because you ultimately do tie that back usually to a C Corp in the United States. Yep.
So what's the range in cost then for an LLC?
It can depend quite a bit, but I would say, an incorporation, which we'll get into, is anywhere between $1,000 to $2,000. This can run you, depending on whether it's international or not, I would say anywhere between $15,000 to $50,000, and even some international structures can go beyond $50,000.
So, are you saying you would set up a U.S.-based LLC for the offshore organization?
No, you'd usually set it up on like the Cayman Islands or a BVI entity. So you'd keep, and that entity would be the entity that, for example, owns all the IP that's developed. So you'd keep all the assets and the main assets of the corporation offshore, and so you would avoid a U.S. tax structure, which is fairly common. A lot of bigger companies put this in place that have, and there are a lot of rules. Again, this is why it's expensive. In order to qualify for that, for example, you have to have a vast majority of your sales have to be overseas. You can't be selling to U.S. companies or U.S. customers and avoid tax in the U.S. But if you have, for example, I work with a company that has 95% of its sales are in Asia, and they have an offshore structure. So they have a Singapore entity, a Cayman entity, and they run all their revenue through the offshore because their customers are paying them from Asia.
Okay.
And so their tax comes down.
So is that appropriate if you open up an offshore development office that's really just serving your development needs?
Well, it's very fact specific, but it can be. If they're doing all the development or kind of the secret sauce development, then you have a very good argument that your IP is actually being developed offshore, and that's ultimately what you're selling to folks, whether it's a licensing model or something. So it may be something to look at. The other caveat there is it's very expensive and very complex to try and do this after you've been operating for a long time. It's very difficult. I mean, the U.S. obviously does not give free passes to folks who want to avoid tax in the U.S. So once you, and again, I don't want to kind of preach that this is a great strategy to use to avoid tax, right? But it can be a very good strategy if your business is legitimately an offshore business. But if you start here in the US, you develop IP in the US, very difficult to take that IP offshore and establish this sort of structure. So an S corporation is again almost on the hybrid side of the LLC equation. But an S corporation from a legal perspective is just like what we're going to get into a C corporation. And a C corporation is kind of what you all think about when you think of a corporation. So IBM, Hewlett-Packard, all the big public companies are C corporations. An S corporation is very close to the LLC side of the equation. And from a legal perspective, you incorporate whatever your entity is, you just incorporate, and you are a C corp. If you want to make a special tax election, which is again separate and apart from your legal entity, you can make what's called an S corp election with the IRS. And that gives you certain benefits. It still gives you the limited liability benefit because you're a C corp, but it also gives you the pass-through treatment as a corporation. And there's just a couple of nuances there. You have to elect it within a certain period of time of you actually incorporating. So you can't, a year after you've incorporated, all of a sudden decide to become an S corp. You have to do it at the very beginning. And so the question is, well, why not just do an S corp? I understand the LLC issue. That's expensive. It's complicated. Let's not do that. But why not just do an S corp? And a lot of companies do start out as an S corp. That's not an uncommon structure. It gives you the benefit of those tax write-offs as you're just starting out. But there are limitations to keep in mind, especially down the road, depending on what you want to do. So the biggest limitation is one class of stock. So you can only have one class of stock as an S corp. So right away, pretty much that excludes 99% of VCs, because when you sell stock to VCs, they want preferred stock. And you're going to be issuing yourself common stock. So what happens in that case, and I've seen this done many times, is the S corp will automatically flip into a C corp as soon as you get a VC financing done. But so that's a limitation. So you most likely, if you're successful and you plan on getting VC money, you're not going to stay in S corp forever. But that doesn't mean you can't start out there. Some other limitations: no more than 100 stockholders, and that was recently increased. It used to be no more than 40 stockholders. And the individuals that own the entity who you're issuing that one class of stock to have to be U.S. citizens, resident aliens, or eligible for trust or estates. So there are some limitations on who can own an S corp in the U.S. Okay.
I have a quick question just on the LLC.
Yeah.
Is there a difference between a single member versus multiple member? Can you have a single member?
You can have a single member. And the difference is the operating agreement for a single member LLC is much more straightforward, because you're not worried at that point about what the rights of the various owners are. And you usually have provisions in there that say, well, what happens when we transfer from a single member to multiple member? How do I transfer ownership? But both are recognized equally under the law. Yep.
Is the S corp at all a red flag to VCs?
Not really, because they know it's just going to flip right away. Yeah. Okay, so C corp. This is what I deal with probably 95% of my time is the C corp, and it has everything we've talked about in terms of limited liability. The pass-through tax that I talked about, I failed to mention. The biggest benefit of that pass-through tax is you only get taxed on income once. So once you actually start making money, which I know doesn't happen right away, if you're an S corp, an LLC, or a partnership, you only get taxed on that income once. If you're a C corp, if you ever want to take money out of the corporation, and to keep this in mind in the practical world, I'm not familiar with a startup in Silicon Valley who's ever declared a dividend because they've been making lots of money. It's always usually reinvested in the company and for growth. But let's say you ever wanted to take money out of a corporation, you would have double tax in a C corp structure. So the corporation gets taxed first because it's viewed under the law as a separate individual entity. So it makes money, it gets taxed, and then for whatever reason it wants to distribute out the money, the income that it has, to its owners. The owners then get a second tax on whatever's distributed to them. That's the dividend or distribution tax on that. So again, but in the Valley and a lot of places in the startup world, dividends are extremely rare. So folks just tend to look past this double tax issue. And it gives you all the flexibility you need to run and grow your company. Multiple classes of stock and as many stockholders as you can imagine. Yep.
I didn't catch why VCs don't mind assets because they know they're going to flip into a C. Why is that predetermined?
Because you can't have more than one class of stock as an S corp, and a VC will 99 unless there's a very rare, there's always the exception, but for the most part, VCs will just want preferred stock. They're not going to take common, so they'll know it'll flip. Yep.
When you pay yourself as an employee or when you pay other employees, is that considered taking money out of the company?
I'm sorry, I didn't.
Oh, when you pay yourself as an employee or your other employees as employees, is that considered taking money out of the corporation?
Yeah, great question. Great question. Yes and no. There are specific tax rules, again, where I know enough to be dangerous on this one, where if you pay yourself too much of an income, the IRS starts to look at it as a distribution or a dividend. But ordinary income that you can justify as being just for services rendered is just taxed to you like an individual would be on, you just go to work for a company and it's just taxed as ordinary income to you. So you're taxed. If the company is making money, they're still paying tax. So in a way, it's double taxed. But it's not treated as a distribution unless you start paying yourself, a $10 million salary, that sort of thing. So there are ways where it can become a dividend or a distribution, but for the most part, it will just be taxed regularly as ordinary income to you as
It's still
an employee.
getting double taxed, whereas with the other ones, it's not, right?
Right, in the partnership. So it may or may not be double tax. It really depends on the corporate tax situation. So, most startups that I work with aren't actually paying tax for the first 3, 4, maybe 5 years. So, and as they're going through those 5 years, they're accruing what's called NOLs, which give them tax credit when they actually start making money. And so you could be paying yourself a salary for 5 years during the time where the company is actually not paying tax and it's not double taxed. But theoretically, it could get there. Okay.
And a related question, how do you know what that cutoff is? Who determines what that is?
Yeah, all I can say on that is the cutoff is very high and that we'd have to talk to a tax attorney. I wouldn't worry about it initially. If you're making that much money to be able to pay you that much of a salary, you can afford a very good tax attorney at that point. Uh-oh. There we go. Okay. So a lot of this stuff we've already talked about, but so this is a slide on how to decide what entity. So taking all that information we've just talked about, some of the other characteristics of your situation could dictate where you start off. So who will be the owners? How well do you know that group? Is it a small group? Is it a one-person group or one person? Are there 5 or 6 founders? What type of financing do you think you're going to get? Are you going to try and bootstrap it so that this core group of folks, it may make sense for them to stay in an S corp for a while? You're not going to look for VC money. You think you've got a nice model that's going to get you cash flow positive without having to raise a ton of cash. And then the S corp might actually be the best thing for you because you're actually going to generate cash and you're going to want to take cash out of that business. And you don't necessarily see yourself being the VC type of company. You see yourself generating a lot of cash. How will you compensate your employees? Are you going to give them stock? It gets fairly confusing and complex when you're an LLC and you've got 50 people owning stock because you got to track distributions. They're allocated tax on income, not necessarily distributions. So it becomes a pretty complicated endeavor if you're going to compensate employees with ownership of the entity. Yep.
What do you mean by pretty complicated? Is it like not recommended at all?
No, people do it, but it becomes expensive. It's complicated enough where you're not probably going to be able to do it and you're not, and if you're capable of doing it, you're probably not going to have time because you're busy running your business. You're going to have to hire an accountant to help you facilitate all of that.
That's why you're weighing up the cost of an accountant.
Yeah.
Does your company do that?
Does my company
Is
do?
your company an LLC?
It is an LLC. Yeah. So we distribute profits, and as a partner, I'm taxed on income, not necessarily distributions. So I pay quarterly tax, and they can be out of whack with the money I'm actually making in that year. So, and you know, we personally have to have an accountant handle our taxes personally, and the firm actually has 3 tax attorneys at the firm dedicated to managing all of that. So it's pretty, but we have,
So it takes 3 accountants to do it.
well, it depends on how big. Yeah, we have 320 partners, so, and some of them are located internationally and that sort of thing. So, yep.
How easy is it to switch between the different ones?
Well, as we talked about, the easiest switch is probably the S Corp to the C Corp because it's an automatic. It's pretty difficult to go from an LLC to a C Corp. Not impossible. You tend to do it through a merger structure, but you kind of have to unwind everybody's ownership and make sure they get into the same place in a C Corp, but not impossible. So you can move back and forth. I would say it's harder to go from a C Corp to an LLC. If you kind of think of it in the order in which we talked about them, to end up in a C Corp and no matter what structure you start out is pretty easy, but to go back upstream can be difficult.
But I thought you mentioned you cannot go to an S Corp unless you start out.
That one you can't, that's right.
So if we already have an LLC, we're
You can convert to
there.
an LLC.
Well, you can go from an LLC to an S Corp. You can't go from a C Corp back to an S Corp. Yep.
For a related question, we formed an LLC to start out with for a variety of reasons, but we're looking on a particular part of the business to be able to do something. We might be raising seed funding, and so we want to figure out whether we do something separate, a separate entity, and have the LLC relate to it in a particular way, or unwind the whole thing and go to an S Corp.
Mm-hmm.
What's the path that makes the most sense, given your,
A lot of it will depend on
and it's simple, it's 2 partners, that's the other.
2 partners, and are they completely separate businesses, or just?
Related but separate. There's no overlapping contracts, put it that way. But it's the same area of business.
But if I'm an investor, do you pitch me in investing in just one, or do you pitch me investing in both?
Just one.
Just one. So I would, somehow you want to spin that out, get the IP from your LLC out into a different entity, and you can do that, and you can set up, interesting question whether you can, I think you can set up an S Corp as that second entity, and then just transfer the assets over. And if there's just 2 of you, that's easy enough in terms of starting out your ownership. You just divide the pie, however you want to divide the pie in one class of stock. It can get a little, complicated if you're ever going to try and find financing for the original entity. There'll be a lot of questions as, well, why did you split it up? What's the true value of what was left over? There'll be a lot of questions you'll need to answer if you're ever trying to convince folks to invest in that original entity. So, is that?
Thanks.
Yep. And then the final thing is, what is the likely exit? And so if your ultimate goal is to make an IPO, it's very rare for example, an LLC to go public. You're pretty much a C Corp at that point. If your ultimate exit is to, as I said, generate a lot of cash, stay the owner of the business, and distribute cash out to yourself, take that into account. I mean, the LLC is a great structure in that scenario. If your ultimate goal is to get sold, build the company up to a certain point, and then try and sell it. If the entity you're selling it to is a C Corp, they may require you to somehow convert into the C Corp before you actually get the deal done. But again, that's not the end of the world. That can be done, but it's just something to think about. Yep.
How does convertible notes in terms of angel offerings work for LLCs? Do they exist for LLCs? And is that, I don't know how you think about it.
Yeah, I mean, they do, and the way they would convert into a membership interest, an ownership interest. So it'd be very similar to, instead of converting into like a next round preferred stock, or even into a common stock of a corporation, you'd issue them a convertible note into some percentage ownership of the LLC. So warrant coverage could get a little tricky. Warrant coverage is where they also get a right to buy more stock or more shares. But I've actually never done that, but it seems like the concept would transfer over the same. So they just get a right to buy more of the LLC. The other thing to think about there is as folks buy more of an LLC, other members' interest is going down, obviously. They're getting diluted. So to the extent you have employees that own a lot of interest, the disclosure around that could get fairly complicated. But conceptually, if you're talking to angels, the ownership structure is still pretty simple. You can get it done. So. All right. Just a quick note on where to incorporate if you're going to incorporate. California versus Delaware. A lot of folks will incorporate in Delaware. I tend to recommend it to my companies. The only reason to do it in Delaware is because, again, the body of corporate law is much more sophisticated in Delaware. It's much more predictable. VCs tend to like Delaware. They're not against California. The cons of Delaware is that it is a little bit more expensive because you're still going to, if you're based here in California, you're still going to need to qualify to do business in California. So, but we're not talking a lot of money. It's $800 to qualify in California. It'd be $800 to incorporate in California. A lot of companies who start out in California, let's say they're extremely successful, on the eve of their IPO, they will reincorporate into Delaware. Because again, the Delaware corporate law is much more sophisticated than we have here in California. So most public companies are actually Delaware corporations as opposed to California. So that's it about that. A quick note on officers, directors, and advisory boards. There are legal reasons why you need officers and directors. Every corporation needs directors. Every LLC needs managing members. You are required to have officers as well. That's the legal side of things. There's obviously the very much interesting conversation you have with co-founders about officer positions, who's going to be on the board. For example, if you have 3 founders, you may not want to put all 3 on the board. I mean, the board is really the body under a corporate structure that controls the company. At the end of the day, the board hires and fires officers, for example. They approve all the material contracts. The CEO, at the end of the day, has quite a bit of authority to represent the company to the outside world, but he or she reports back to the board. An advisory board it's a term you may have heard quite a bit. You have technical advisory boards, TABs, or you just have general advisory boards. Those, under the law, have no authority. They're there, a lot of times they're there just simply as a resource to the founders or to the management team. And whatever those resources might be, whether it's contacts, business advice, technical advice. But under the law, advisory boards do not have any authority at all. The actual required officers in a corporate structure are the president, treasurer, and secretary. The same person can serve as all 3. And in fact, that's typically common. Most common scenario I see is, let's say it's 3 founders. One founder is clearly the driving force behind the entity. A lot of times that one founder will be all 3 of these. If it's more egalitarian, everybody's kind of equally involved. No one's kind of leaving their one job to come and try and help develop something. Sometimes you'll see this split. But as an early startup, there's really not a lot of difference between what these things do. It's almost who needs to sign the incorporation paperwork, and that's almost it. So those are typically the same people. Yep.
So all these apply to all types of corporation or just S Corp, C Corp?
S Corp, C Corps. LLCs are different. You have what's called managing members. You can still have officers, but under the law, really, your operating agreement controls all that. So whatever you want to call folks, whatever you want a president to do, whatever you want to do, you put the job description in your operating agreement. But under Delaware law for a C Corp, for example, there's specific things that a president is authorized to do. So that's why the operating agreement can be a little bit more expensive, because you want to think about what your officers are really authorized to do.
Did I understand you say that all 3 can be the same person?
Yeah. I'm not familiar with nonprofits. Sorry. No, I don't do a lot of nonprofit work. Are they required to split out those roles?
The bylaws we have say that.
Okay. And
It depends on the bylaws.
it probably depends on the bylaws. That's a good point. Certainly the bylaws in a C Corp can also separate those out as well. The number of directors, as I said, sometimes you have a founding group of 5. You might not want all 5 founders on the board. There are some requirements, and they depend on where you're incorporated. Delaware, again, gives you a little bit more flexibility than California. California says you have to actually have in your bylaws or your articles of incorporation a specified, either a range or a specified number of directors, and that range can only be a certain range of or number of directors. And then if you want to change that, you have to go to your shareholders and get it changed. Delaware basically just says you can put a number in your bylaws, but the board can change it anytime they want if your bylaws actually say your board can change it. If you can start out with 1 director, you can be a sole director as a founder. If you issue shares to more than 1 people, though, you have to start increasing your board. So if you have 3 shareholders, you need the minimum number of directors you can have under California law is 3 directors. Delaware, again, gives you more flexibility there. So, just a quick note on kind of the typical board structure. The one that and if you're thinking about getting VC money, one of the things you want to think about is, what's my board going to look like after the Series A round? What's my board going to look like after the Series B round? Because more often than not, the VCs will, fair point, ask to have a member, their partner, on your board. Some take observation seats where they're not formal board members. They just go to the meetings and don't have a formal vote. But most of the time, they will ask for a formal board seat. So you should think about, in setting up your board, and even when you start out, what's that board going to look like? And the typical structure is kind of two directors who represent kind of the founding group. So the common director and maybe the CEO director as well. And then a lot of boards start out a board of 3, so that the founding group obviously controls the board. And maybe you have an angel sitting as your 3rd member, or maybe you keep that 3rd seat vacant if you can. Then as your Series A director comes on and your Series B director comes on, your board starts to expand, and they will get their seat. And you start to lose control over time of your board as the more money you take on from outside funding. This isn't always the case. I mean, I've seen Series A deals where you have co-leads, co-investors, and each one of them get a seat. So right off the bat, after you raise money, it can be an equal board, 2 and 2, for example. So, yep.
What kind of liability does a board member have?
So a board member under a corporate structure has very limited liability, as we mentioned before. There are certain situations where you can have personal liability. Very rare. The most common term is called piercing the corporate veil. It's kind of a glorified term, but if you're not, for example, following your corporate formalities, and this is kind of an important thing because a lot of startups, when they first start out, they don't necessarily, we only have 3 shareholders, we've got 3 directors, everybody's the same thing. We don't need a board meeting because we all know what's going on, so we're never going to have a board meeting. We're never going to do any shareholder approvals, that sort of thing. If you don't follow the corporate formalities even early, you can end up in a situation where the corporate veil gets pierced, for example. And you can end up having a personal liability because whatever is going on, the plaintiff attorney comes in and says, you weren't really a corporation. You just filed something with the state, and then you continue to act as if you were just a bunch of individuals running a business. You never held board meetings, you never did that. So it's important that you make sure every once in a while you have a board meeting just to document formal approvals and that sort of thing. But that is very rare, the piercing of the corporate veil. The body of law around that is very hard for someone to prove that you should have personal liability once you form a company. The other way where you can get into some trouble is if the company doesn't actually work out and you're starting to wind down, and you don't, as a board member, you don't set aside enough funds to pay what's called statutory obligations. So like any employment tax, if folks have come to work for you as employees and you don't have enough money to pay them for what they've already done, you can have some personal liability as a director as well. So there's certain things that are statutory that result in personal liability. But again, those are also very, very rare exceptions, because most of the time you just go into bankruptcy or you do what's called an assignment for the benefit of creditors, and you kind of walk away as a director, unless you've violated your duties so bad that you haven't set aside enough money for certain things.
What about Sarbanes-Oxley? Doesn't that put some people on the hook?
It certainly puts some people on the hook, like a CEO and a CFO. They sign certifications, both criminal and civil certifications. So they absolutely, but usually that doesn't look to the board. The board tends to get insulated from that sort of thing. So. Oh, yeah.
If the founders are in different places, is there any requirement that board meetings take place in person, or can those happen online? What's the requirement for a formal board meeting?
Yeah. Absent some strange provision in like your bylaws or your articles, it can take place anywhere. It can take place by phone, and it can actually take place by email as well.
Okay.
It's not necessarily a meeting if you do it by email, but you can get certain approvals done by electronic mail and electronic means. And you can have a, like a go-to meeting or something over the phone or a webcast or something, and that qualifies. Absolutely.
Thank you.
Does that have to be called a board meeting, or can you just have like regular meetings, and if someone were to inquire if you're really a business, you just say, listen, look at all these notes, we've got our agenda, we've got our follow-up.
Yeah, that's the second best scenario where you've got all that. I would go to the trouble of actually calling at least one or two of those every 6 months a board meeting. All right, structuring ownership. And again, from this point forward, I think I'm just going to focus on corporate structures, because that's kind of what I do mostly. LLC is slightly different with membership interests. Some of the concepts translate a little bit, but not always. So structuring ownership, the way to kind of look at this is your founding stock, your founder's stock, and then kind of everybody else. So there's kind of 2 points in time, but you should start thinking about both points when you're starting to divide up the pie for your founder's stock. So let's first talk about dividing the founder's stock up. Oops. So the founder's stock, I think this goes without saying, is an allocation of stock among founders. You do actually have to pay for the stock. That's one of the things the law is very clear on. You actually have to, as a corporation, you have to issue stock for valid consideration, and we can get into that in a second. And you also need to start thinking about, should I have this founder stock subject to vesting? And for those of you who don't know, vesting is a concept where you don't actually own the stock on day one. Something has to happen, whether it's you're staying with the company and just working, or there's some performance that has to get done where you actually vest in the stock, and at that point you actually own the stock. So you start thinking about that as well, particularly if you have more than one founder. So the advice on splitting the pie is, one thing to remember is you only have 100% of the company. I can't tell you how many times I've sat down with founders where they divide more than 100% up. And it's a very awkward situation. But when you're sitting there on your own, or before you go into an attorney's office or whoever you're going to meet with, always keep in mind that there's only 100%, and that 100% is going to turn into less than 100% if you're successful. But remember, it's only 100%. The pie is only as big as it is. And start early, because you never know, things may take off very quickly for you. And I've also seen this too, where they say, oh, we'll get around to it later. And pretty soon you've got VCs knocking on your door and you haven't actually divided the pie yet. And it becomes a very different conversation once you actually realize that this thing's fundable, about who's put in the most time, who maybe someone didn't put in time, but their idea really elevated the entity. And it's a lot different conversation then than it could be up front. So start early and only 100 percentage points. Talked about consideration. So there is a legal form of payment for the stock, and usually what we like to do is not have you actually pay a lot of money to get your founder stock, because the founders are the ones that are going to make that stock valuable. And so what you either do is one of two things typically. You either peg the price at like a hundredth of a penny. So the most common scenario is maybe set aside 10 million shares, 5 million shares for the founders. So if you're going to own half of the founder shares, 2.5 million shares, a tenth of a penny or a hundredth of a penny is not going to have you write a big check for that. If you don't want to pay money, that's okay too. What we usually do is if you created anything before you actually form the entity, whether it's a website, maybe it's a provisional patent application, which we'll talk about in a little bit, you can contribute that in to the entity, and that's your payment for the stock. And you can do that on a tax-free basis. There's a way to do that tax-free. So let's see. This is also a great opportunity to make sure that each founder who's getting shares is actually contributing everything that relates to this company into the company. So the worst thing in the world, and I've seen this happen unfortunately, is you get three founders together. They're all committed on day one. One founder's bringing something he kind of worked on in the past. Another founder is bringing her relationships to the table. And the other founder is just going to be dedicated and work this thing and bring everything together and be the kind of fundraiser of the group. Well, what happens when the person who's bringing the IP, something that they've worked on in the past, doesn't actually contribute everything? That becomes a big problem when that person wants to leave because the company does not own it. And so this is a great time to make sure everybody signs what's called an assignment of inventions agreement or a proprietary information agreement and contributes everything into the company that they're bringing to the table. And that could be as simple, by the way, as a domain name. Maybe someone's gone online and registered their domain name for the company. And if they don't contribute that in, they still own that domain name. And you build up a huge brand based on that domain name. And 2 years from now, you find out that the company doesn't actually own it. And that maybe that person's left. So something to think about. The 83B election has to do with vesting. And one thing you want to do when you're setting up your founder stock is not have to pay any tax on stock that at that point in time is worthless. So the worst thing to do is set up a structure where you actually get stock that no one wants to buy from you yet, and you actually have to pay tax on it. The other thing to keep in mind is if you put in vesting, and we'll get into vesting in a second, every time you vest in your shares, that could be a taxable event. And so if today you pay, let's say you pay $100 for 1 million shares, the fair value of those 1 million shares is $100. But let's say you have a cliff vest, and in 12 months you're actually gonna own 250,000 shares. And in that 12 months you've created such a great company that the fair market value of the stock, instead of being $100 for 1 million shares, is now $1 million. It's now $1 a share. Well, as you vest, the IRS says that's a taxable event, and you've just gained $999,900, and you need to pay tax on that, even though you can't sell your stock. So the way to avoid that is on the day you buy your stock or within 30 days of buying your stock. I think it's 30 days. It might be 90. 30? Someone's seen this. There you go. You file your 83B to make sure you don't have to pay tax on that vesting event. And the 83B election basically says you agree to pay tax on the day you buy your stock based on the difference in value. Well, for most people, there is no difference in value. They're just paying the fair market value. So there is no tax event there. And you defer all the way through all your vesting provisions until you actually sell your stock. So if you ever go to sell your stock at a merger, or if your company makes it public, you sell your stock, you then pay the tax based on that gain. But you don't have to worry about each vesting. Yep.
So what is the day that you buy your stock? Is it the day that you incorporate, or is it the day where, if you're putting, let's say, sweat equity into the business rather than actually paying the penny or 100th of a penny per share, what's that actual date where the clock starts ticking?
So it's basically when you sign your founder stock purchase agreement. It's not when you incorporate. Sometimes they're the same day, but oftentimes they're not. Yep.
Is founder stock different from the shares you start from? Or is that the
Same
same?
thing. Same thing. Yep. And it's usually common stock. I refer to it as founder stock just because it's the stock that's going. As I said, at that point, 100% of the ownership is in the founders. So I just call it founder stock, but it's usually common stock. Yep. By the way, just one final note on 83B elections. If you haven't filed them, some folks are doing it. The consequences for not filing them can be so significant that a lot of law firms just refuse to file them on behalf of folks in case something goes wrong, because the liability associated with them, it can be so significant. And so it's something you want to definitely pay attention to. If you're working with somebody and they mention the 83B, make sure you follow up with them to make sure it gets filed. Yep.
So if you have, so I have counsel for the company, and I have also personal counsel handling all my stuff separately. Would you recommend having my personal counsel actually file it on my behalf, or just doing my, I mean, it's obviously I have to pay more legal fees, but is it better?
Not necessarily, but I would certainly put a phone call in and have someone shoot you an email to say it got filed. And either your counsel can follow up with your company counsel to do that, or you can do it.
When you say it got filed, what do you
Just
mean?
making sure someone puts in writing that it was filed, the 83B election was filed on your behalf, because it gets filed with the IRS.
So one thing you
Right.
can do is include a self-addressed stamped envelope, a
That's
letter
what
to
I
the
was doing.
IRS.
Yeah.
And when you file it yourself, include that letter, have it come back to you, they'll stamp it,
And
they'll
then
date
let
it, and
company
it'll.
counsel know, but do I need to get personal counsel involved? That's how I was
No.
going to do it.
No.
As long as you can find the form and somebody
Yeah, I
gives
have
it
the
to you,
form I sent,
to
yeah.
just send
Yeah.
it and make sure you include that letter so
Yep.
you have proof that you have
Fantastic,
that.
okay.
Exactly. Okay. I'm not sure we'll spend too much time on vesting, but basically some of the things to think about. Investing really comes into play if you have more than one founder. If you're just a single founder starting your own company, there really doesn't make a lot of sense to put vesting on yourself. But it sure does. But there could be a situation where it does make sense, and we'll get to that in a second. But if you're with multiple founders, and this may sound horrible, but the people who are around the table with you may not be with you in 6 months. And if you immediately vest everybody, that person owns that stock no matter what, whether they've been there 6 months, 2 months, or 4 years. So it's always a good idea, no matter how well you know your founding group, to put some vesting. And the way I always describe it when you're around the table, because it's an awkward moment and everybody says, oh, we're never going to leave the company, we're all in this together. The way I describe it is it's just a fairness issue. It's just an absolute fairness issue. If someone leaves in the first 6 months, 9 months, it's just not fair to the other founders that person continues to own all their stock. There are certain accelerators you can put on that. For example, if your company gets acquired, if the person is, and this is true, by the way, for any options you would issue to your employees as well. Changing control accelerators, there's termination without cause, constructive terminations, all sorts of kind of bells and whistles you can put around vesting. The one thing you do want to do if you actually issue stock, particularly to employees, is make sure that the company has a right of first refusal on any transfers of that stock. So kind of a common thing now is even for private companies to have these kind of secondary markets for their shares. What you don't want to do as a company is have those shares end up in your competitors' hands. Because all of a sudden, sometimes if you accumulate enough shares in a high enough percentage, certain rights and information rights can flow with those shares. And so you want to have the ability as an entity, as a company, to be able to buy back shares from your employees if they leave, and usually at cost, so they don't get the appreciation. Certainly if you issue shares that are subject to vesting, but you're actually issuing restricted stock, so those folks actually own the stock, because there's a difference between an option that vests over time and gives them the right to buy stock over time versus issuing somebody shares and have that subject to vesting and forfeiture coming back this way. Does everybody kind of understand that? So if I'm a founder and I have vesting, usually I'll get the shares and I own the shares today and I'll file my 83B election and I own those shares. But they're vesting over time. So I can vote those shares today, but if I leave and I haven't vested, the company has a right to buy back those shares from me at cost. An option, on the other hand, if it's not vested, I don't own any shares. I just have a right to buy shares. So it's a different animal. So you want to make sure that your agreements with your co-founders give the company the right to buy back shares if they were to leave. Yep.
So the at cost, that can mean hundreds of penny.
Yeah. Yep.
If you want to be a 100% owner, but you have some key employees who you'd like to give some sort of profit sharing incentive, can you avoid all the kind kind of share allocation and option allocation just by structuring an employment agreement that specifies if with this vesting schedule and this kind of achievement of certain objectives, you're entitled to such and such percent of income?
Yeah, I mean, it sounds like what you're describing is an option to buy, and the right to buy is triggered on certain things.
Not right to buy a cash bonus based
Oh, a cash
on
bonus.
achieving certain objectives linked to the profitability of the business.
Yeah,
So
no,
it's-
absolutely. You can give whatever cash
But
incentives
that's
you
more
want.
of an employment agreement,
That-
would be.
Right, right. Or an incentive agreement. That's exactly right. Yep.
If you're dealing with a kind of trying to set up a founder agreement for the initial stock and for the vesting and stuff, and with the situation where one of the founders is going to be like full-time and some of the others are going to be putting in very small amounts of time for
Mhm.
at least the immediate future, are there examples or guidelines to like how you set up a good, we have no idea what kinds of structures would therefore be, it seems useful to build in how much time we're going to be putting in into vesting somehow, but we don't know what kind of agreement to,
Yeah.
are there resources for?
Yeah, I'm not aware of like online resources or anything like that, but the quick answer to your question is, allocate the shares appropriately. So it may be the same vesting schedule, but because someone's putting in less time, and then you could put kickers. If for example, I've seen situations where someone's consulting, but they're still part of the founding group, but they don't want to leave their full-time job. That person gets a much smaller grant, but there's something built in their offer letter that says if you switch over, if you leave your job and become full-time, you'll immediately get this grant for this many shares. So I've seen that happen before. Yep.
Can you just talk quickly about the difference between financial ownership and board control, financial control and board control? Because you said, so in California you could have 3 board seats, but I'm a sole founder and sole owner of the company, so I have 2 other people, so in theory I don't actually have board control over the company. Do I appoint the board at will? How do I still maintain control over my company in that case?
So the board serves at the direction of the shareholders.
On a per share vote basis?
Yeah, on a per share vote. Yeah, in California you have something called cumulative voting. So in California it's possible that you can end up with someone who owns 34% of the company and can still vote on a board of 3, can vote 1 director on because they accumulate their votes for that 1 director. But for the most part it's usually majority wins. And so certainly if you own 100% of your company, you control the board.
That's obviously the extreme example. But
Yeah, but it can get messy depending on the situation, and it's not as simple as saying, I own 50%, so I now control the board. There are procedures you got to follow. So in a tough situation, it can get pretty messy. But basic rule is the shareholders control the board and can elect the board and can remove the board as well. Okay, so any questions on vesting? We're running up a little bit on our time here. So we talked about employees a little bit. First question oftentimes I get is, we don't have any money, so can people just come and work for free? And the answer to that basically is no, unless you want to take on some risk. And the risk is down the road, under California law certainly, you can't work for free. You have to make at least minimum wage. So even with a founding team who is literally just going to kind of hit the ground running, they don't have any cash, they're just going to work out of somebody's house for the first 6 months and see if they can get funded. If they incorporate, I always tell them, pay yourself minimum wage. And it's not only to avoid a situation where someone leaves and then brings a suit. It's also because VCs will actually look at that to say, do we have any potential liability here if someone leaves and they didn't get paid any money? So the answer is you can't work for free. You can structure a deal, certainly if you're a consultant, where you're working for equity. But the thing to be careful about there is you want to control the fair market value of your stock, because you want to, as a founder, you want to be incenting anybody you're bringing on, and the best way to do that is to issue them cheap shares, right? And so one way around that is when you sell stock to VCs, for example, you might sell them preferred stock at $1, but you're still issuing options that give your employees a right to buy stock at 5 cents or a penny. And the reason you can do that is because the preferred stock has certain rights over the common. But if you go out and you hire a consultant and you put in the consultant letter that says you're going to give me 10 hours a week and I'm going to give you 5,000 shares, well, someone's going to back in to a fair market value based on those 10 hours and how much those 5,000 shares were going to last for that consulting relationship. Maybe it's a 6-month deal. So you just want to be careful and not screw with your valuation on your common stock there.
Question on that, are there legal implications of someone back into that fair market value, or is that just a negotiated point?
No, there are legal implications because it's how your tax is ultimately driven. And so folks who invest in your company get nervous if they see a situation that may lead to a higher fair market value. And now there's something called, oh gosh, I'm going to blank on it now, 409A, which some of you may have heard. 409A is a new tax code provision that basically says if you do not grant stock at a fair market value, you actually could end up with liability. This is another situation where you can end up with liability as a personal level as a board member. And there are all sorts of bad tax consequences to the individual who received the stock at something less than fair market value. So if you have something in your corporate history that shows that somehow, some way through some consulting relationship or something, that stock should have been valued at $1 a share, and for the next year and a half you've issued options at 5 cents a share, you've got a pretty big problem on your hands.
So the letter that a consultant should say X dollars, or I don't know, X dollars per hour plus Y shares?
Yeah.
Okay.
Yeah. And that X, it can be fairly low, but it's just something, and it sounds very strange, but it's just something you want to be able to point to somebody that says their services really were valued at this $1, and then this was the extra kicker for the stock, and that was, a penny a share, basically.
Would convertible debt just be easier then?
What's that?
If they're interested in having some ownership, would convertible debt be an easier way of doing that?
For a consultant, probably not, because on convertible debt, I guess the debt is accumulating as they're providing you services. Yeah, I guess you could structure it that way. The only problem is they'll have income as they go on that debt. So they'll have income on something that's not valuable to them. If you pay them a little bit of cash, they'll have income on that cash, but they won't have any taxable event on the shares, assuming they make their 83B or anything like that. Yep.
But that's deferred compensation, right?
That's the 409A.
What you just mentioned is another way of saying deferred compensation.
Which one? The
one with
debt?
question,
Yeah,
which VCs frown upon.
absolutely. And that's because of the 409A situation. Yeah. They don't like the 409A. 409A kind of changed the world a little bit in how you issue options. Yep. Yeah, regardless of your structure, you want to pay the minimum wage for employees. Again, consultants can be different, and a lot of times startups will walk a very fine line between who's a consultant and who's an employee. But if you have health benefits, for example, and you're paying someone's there full time, they start to look a lot like employees. So you want to make sure they're getting minimum wage at least. Consultants are a different animal, really.
That was or stock, right? Minimum wage or stock.
You always want to pay them at least minimum wage in cash. You want to pay them a wage. Yep.
Sure.
Yes, it seems like the consultant is a pretty common thing.
It is.
Can you clarify how we should structure it? Like I have a consultant and I pay him a certain amount, but when he works on this startup, I'm gonna pay him less, and I'm also gonna give him shares, even if I don't write down on paper this share is covering the discount you're giving me in the rate. Am I still kind of setting a value there, or
I don't think you're setting a value. If you're clear,
I'll say in a conversation with them, here's how I'm valuing it, but we just don't put it down on paper.
that's right.
enough?
That's the reality. Yep.
I would say in the conversation, you should not say that. You should explicitly say, we're not gonna do this as cash. We'll have a 2-year vest or a 1-year vest for X number of shares. We have a bunch of objectives we're gonna do. You actually explicitly wanna say, we're gonna avoid any kind of implied cash valuation of the stock.
Yeah, formally. I mean, they may ask you though. The reality is they may ask you, well, what are these shares worth? I mean, I don't have any, and you can kind of dance around it if you want. You can say, well, this is what percentage of the company it is. You make your own valuation decision. But you want to absolutely avoid putting anything, certainly in writing, on valuation. Okay, I think we talked about this. I guess the one thing to highlight is the last bullet point there. There are no secrets, particularly when you start to hire more employees. There are studies out there in terms of, what is a manager of this level, what percentage ownership do they get? There are compensation studies out there, but one thing I like to tell CEOs and CFOs or management is you should assume there are no secrets. Technically, employees are not supposed to be talking to each other about what options they got and how much ownership they have. But one general rule to keep in mind is those folks are probably going to be talking to each other. So you should keep that in mind as well. Yep.
I don't know if you mind going back to the previous slide.
Sure.
You have exempt versus non-exempt. I was wondering if you can talk about whether if you add in a bonus, if that makes someone exempt, or non-exempt if they weren't certain outcomes.
Yeah, the exempt versus non-exempt, I don't think it matters how much you pay somebody. My understanding is it really depends on the character of what they're doing for you. That may be one of the factors they take into account in terms of how much you pay them. But the significance, by the way, of exempt and non-exempt, for those who don't know, if you are a non-exempt employee, and sometimes I get this backwards, but in one case you cannot, you can have someone work overtime and not pay them overtime. So that's the non-exempt. Thank you.
Sorry, forgive me. That's exempt.
That's exempt. Okay.
Yeah.
See, it's confusing. It's confusing.
For every hour
Okay.
if I'm non-exempt.
And so, several years ago, there was these rash of cases where class actions brought against corporations for companies that made folks, well, not made folks, but folks were working overtime there, and they were treated as salaried employees, so they had an annual salary, and they weren't getting paid overtime. And the main issue on those cases was an exempt or a non-exempt employee. And you could end up paying overtime wage plus penalties plus interest if they should have been categorized a certain way if they were working overtime for you. And I think it really goes to the heart of the issue really is the nature of their services and whether they had kind of a managerial role. I don't know the exact test, but I don't think it hinges on how much you pay somebody. So, yep.
Can I just ask the question I'd love to hear an answer to before we're done about how you contract with your lawyer? Because I know that there are lots of different arrangements that, especially around the valley, that different firms are prepared to come to about what you pay for up front, about when there's a liquidity event, maybe you won't have to pay anything until that point. Just from, however you do it, but give a perspective of what makes the best arrangement as far as you're concerned for founders and their lawyers.
Sure, great question. And we refer to those as alternative fee arrangements, is how we refer to those. There is a wide variety out there, and certainly, especially in the most recent downturn, law firms and even VCs who work with law firms day in and day out really had to look at their fee structure with respect to startups, because it just doesn't work, particularly for a big firm like the one I work for. You can have like a first-year associate billing out at like $350 an hour, and that just does not make sense for a startup. And so what we do
Does that make sense
for a startup.
But who doesn't make sense?
Well, that's a longer conversation. Happy to have that with you later. But on a more positive note, there are a lot of firms out there who are deferring fees. Some firms take equity in exchange for fees. And so I would certainly ask your lawyer what they're capable of doing. The most common structure that I use is a simple 6-month, the later of 6 months or first funding event. But you really have to have a dialogue with your lawyer, because the worst thing that can happen is that they've run up a bill that's still sitting there, and if at the end of the day you don't get that funding event, they still may come collecting. A lot of lawyers take the kind of long-term view and will like to catch you on your next startup, but some will not, and some will come after you for a $90,000 bill because they've been racking it up the whole time. And so what I tell the founders I work with is, listen, if we're at 10,000, I'll come and talk to you. And we also budget certain projects. So like the incorporation, I'll say it's going to cost you $1,200, but you're not going to have to pay for it, but I want you to know what it's going to cost. And so I would do two things. One is see what kind of arrangement they have out there, and two, make sure you're communicating back and forth as you go. Yep.
You were saying come after you. Are you implying personal liability there, or do we have personal liability?
No, but they'll look to get collection, yeah, whether it's whoever's going to pay them. And a lot of times, unfortunately, and we don't do this at Pillsbury, but they will just farm it out to a collection agency. So just like any other bill.
But to collect against the entity?
Yeah.
Okay.
Yeah. Ultimately, you can't be, if you've incorporated, you can't be personally liable.
Depends what small print the law is.
That's true. Look at that's a great point. Look at your engagement letter. I mean, they have to, by law, under professional responsibility rules, have to give you an engagement letter that outlines under what circumstances they can collect and that sort of thing.
My engagement letter advised me to seek attorney's counsel before signing the engagement letter.
That's a common.
Circular reference.
Yeah. Yeah. Yeah.
On the next slide, you have a question about how much is enough in terms of allocation of stocks to employees. I'm wondering if you could give a rule of thumb as to if you bring an outside CEO, VPs, and what percentage do you typically see in those type of engagements?
Yeah, and it depends on when you bring them in. But if you're bringing them in at the outset, like if you're the technical person and you want to bring in somebody who's got more of a business background, so they're going to be there at the beginning and they're taking on a lot of risk, you could see them with a share just like all the other founders. If they're getting brought in maybe because you're ready to start fundraising and you've already built up a big chunk of the IP, that's a different animal. So sometimes that's 10% or lower, depending on how many people are involved at that point. Usually if you bring a CEO after a couple rounds of financing, they're still looking at 5 to 10%, sometimes more depending on the talent you're bringing in. So, yep.
We talked about alternative fee arrangements, and your firm is an LLC. So if I was going to partially compensate you in stock, the stock would go to the LLC and get distributed. Is that also true for if you were a corporation, or, I mean, does the stock
Different
go
firms do it
or-
differently.
Okay.
Different firms do it differently. And sometimes, and this even happens at LLCs, the partner that's working on the account or the associates working on the account will also get a portion of the stock that comes over. So it varies dramatically as to what firm. And some firms will not take equity. Some firms just say, for professional responsibility rules, we don't want to be an owner in your company. That tends to be the exception in the Valley, but some firms definitely take that position. Yep.
For C Corp early stage, first round of angel financing, what sort of additional insurance do you recommend on top of kind of the usual corporate packages? Do you get insurance for the key players and the board members? Is it too early?
After the first seed, you said, first round? It tends to be early. Yeah. Some VCs require it. It depends on who your angel is. They require D&O insurance. Yeah. And they also sometimes will require key man insurance. It kind of depends on that. More often than not, I don't see that type of insurance after the first round. After the second round, you start to see it. It spikes up, yeah. Yep. So let's just talk real briefly about IP, and then I probably have exhausted my time. So most of you probably know there are different types of IP protection. These are kind of the four main types: patents, copyrights, trademarks, trade secrets. If you can get a patent, that is probably the most protection that you can ever find yourself. And there's different theories about patents, whether they're great defensive measures, whether they're great. Sometimes they can be great if you're out there fundraising. Just to even say you've applied for certain patents, people like to see that. At the end of the day, it can take 3 to 5 years to get a patent issued, and whether you can actually get it issued is a whole different animal. But in terms of the hierarchy, a patent protection on whatever you've got, and some things that you consider technology might not be patentable, but if you can get a patent, that's value in your company. Copyrights are slightly different. Those have to do with protecting written work. So sometimes people will try to have software code copyrighted. Trademarks, obviously if you're building brand, it's great to get trademark protection on that. Some people will try to claim protection under trademark law without actually filing for a registered mark. But your best bet is always to try and, especially if it's your main mark, your main brand, is to go file for protection. And trade secrets is kind of a catch-all. It's what you rely on. If you can't get patents or copyrights or trademarks, you've generated things that are confidential and proprietary to your business. And you can oftentimes sue folks for theft of trade secrets, you may have heard. but the body of law there is not as straightforward as if someone's infringing a registered patent, for example.
Quick clarification.
Yep.
You said sometimes people try to get copyright on their programming code. Is that like that's standard and they succeed, or is that?
Yeah, I think there's a whole controversy on whether you can actually get copyright protection on code.
Okay.
So I don't know much beyond that other than it is an issue. Yep.
So if you hire a development team to develop a technology that's kind of yours, like a proprietary technology, would that be basically solely yours, or the development team would also be able to file some patent there?
The thing you should do is get them to sign an agreement that says it's going to be yours, or the company's. So it's assignment of inventions and proprietary information agreement that says basically you agree that everything you work on in our relationship is owned by the company, and you agree to assign it and sign anything that I would need you to sign to make sure it's assigned over. And if you've got technology that you've developed that's unrelated, or you developed it before you started this relationship for me, put it on this exhibit so I know that it's not going to be owned by me or by the company. But you certainly want to get that in place. Otherwise, they will be able to claim, I just developed this on my own time, and it's messy. It's messy. So just a quick note on costs. A very common strategy for startups is to file what's called a provisional patent application, where it's almost like a quick and dirty patent application, where it's very simple to create. It doesn't go through for those of you who are familiar with patent applications, they often have very lengthy claims that you're claiming on the IP. A provisional is a lot more general, and it starts the clock running for your protections. And it gives you 1 year to turn that provisional into a full-blown application. So it's a great tool for a startup just starting out that wants to start the clock running on some protection. And it's confidential, so when you file it, no one knows about what you're doing. And you have a year to turn that into an application, and it can be, I think our IP folks say it's anywhere between $1,000 to $2,000 to do a provisional. Could be even cheaper if you guys have done them before. You can actually do most of them yourself. Versus a full application can take anywhere between $10,000 to $120,000 depending on the complexity of it all. If you're going to be talking to VCs, it's a great thing to be able to say we filed 4 provisionals in these areas. This is what we see as the value and the core behind our company, and we've already started a strategy to protect that value. And these are our provisionals. And I think we've talked a little bit about the value of an IP portfolio. Certainly if one of your exit strategies is an M&A situation, to be able to point a potential acquirer to a patent portfolio is extremely valuable. Because otherwise you're just really selling them trade secrets if you don't have something behind it.
Do you have a rough estimate for trademark protection?
I don't. I think it's under $1,000 for the actual register, and then $600.
Yeah, go to the USPTO site. It has all the information.
There you go.
But it's actually USPTO. It's actually not all that complicated, but their site isn't very well designed. So.
Yeah.
For a trademark, is that? Because for a trademark, you'll often want to do a search, and if you pay a firm to do that, it can be $500, $1,500 to do the search before you file.
But you can search on that site and see who's using it and for what, and see just at a high level whether you think there's going to be any conflict.
You have to do the search yourself first, look around.
We just did one, it cost about $1,200.
Yeah, that sounds about right. About $1,000, maybe a little bit more. And then there's some costs down the road in terms of maintaining the mark. And if there's an office action, sometimes if there's a similar mark, maybe a different business, it can be more expensive because you actually have to respond to it. Yep.
NDAs, the pros and cons, when you start getting further down with partners and actually showing financials and things like that. Recommend it, don't recommend it, simple form?
Simple form is good. Yeah, and I would recommend them. I mean, I can't really see a downside, quite frankly, unless it turns somebody off and says, oh, it's our policy not to sign them. But my recommendation would be to get them, because that's...
VCs never sign them, but...
certainly investors will never sign them. Yeah, investors will never sign them. Investment banks nowadays are starting to sign them. Yeah, but VCs will not, just because they see so many business plans, it'd be impossible for them to overlap.
Some strategic investors will sign because they want to do a mutual
Yeah, and if that strategic offers you an NDA, you should get it reviewed because there can be some bombs in terms of residual clauses in their form of NDA that you want to be careful of. We're wrapping up. So 3 things to remember. Just make sure you start with the proper infrastructure. We talked about that. There are a lot of considerations in terms of the type of entity, when to incorporate, whether to go with an LLC. But what you want to do, especially if you're going to be looking for funding, is make sure you start off with the proper infrastructure. We talked about the stock ownership, 100% of the pie, but have that discussion up front. Don't wait until it's too late. And then final word of advice is to really leverage your angels and make sure that your board and your board of advisors is part of your team. Any other questions? Or
Quick distinction of founder stock. If a key consultant takes an increasingly large role, can you ever give that individual founder stock, or is it
I wouldn't.
possible after the original agreement is signed?
Yeah, I wouldn't get caught in between founders and common stock. It's really, it can be, founder stock is common stock, so you can increase.
Liquidity preference for founder stock?
Not really, not really. I'll be around if anybody else has any questions. Thanks.